everyone. Welcome to today's Ciphr webinar, Employment Law with our friends at Shoosmiths. It's great to have you with us today. I'm Catherine, I'm Head of Content here at Ciphr. Joining me is my colleague, James Watmore, who's Sales Manager. Hi, James.
Hi, everyone. Thanks for having me.
And then our friends from Shoosmiths, we've got Stuart Lawrenson, who's Partner and Head of Southampton office. Welcome, Stuart.
Morning, everyone.
And we've also got Sian Hoare, the Legal Director. Welcome, Sian.
Hello.
And also not pictured, but very much with us is Antonia Blackwell. She's going to be helping us field your questions today. Welcome, Antonia. Just a quick overview of the agenda. We're going to get straight into it today. James is going to give you an overview of Ciphr, what we do, and our products, and then we'll dive straight into the employment law update. There is an opportunity at the end to ask questions. You can send them in using the chat panel that you can see on your screen. So do take time to say hi, talk to your fellow attendees today and send in your questions, and we'll revisit those for our Q&A. This webinar is being recorded and the recording will be emailed to you afterwards, probably tomorrow once it's all been processed. So that's enough from me. We're going to really get stuck into it. I'm going to hand over to James for a quick overview of who we are and what we do.
Thanks, Catherine. And again, hello, everyone. Thank you for joining today. And also to anyone that's watching this back as well. So for the next sort of 3-4 minutes tops, I'm going to give you a very quick introduction to Ciphr, who we are and what we do. So Ciphr, we specialise in people management solutions. So it's not just about tech. For us, it's really about creating partnerships with our customers to understand your business and to help you grow and develop your business, with the sort of end goal being that sort of utopia of having easy access to understand people, data and processes. You can really make those sort of strategic decisions. In terms of us, why we're trusted, so we've been doing this a long time. We've been around for more than 25 years now. We're UK based. We have more than 1.5 million users of our solutions, and Ciphr's deployed via browser. So what that basically means is that as long as you've got a device and internet, you can access the solutions from anywhere at any point in time. We've got all the appropriate accreditations around sort of ISCO, as you can see there on screen, that should hopefully give you that reassurance and comfort that we're the right provider for you and can keep your data secure. So what is it that we actually do then? So people management solutions, it's about giving you the ability to align our software with the various touch points of your employee journey to sort of achieve that, single source of truth, single point of data entry. And that starts at the beginning of the employee journey around recruitment, helping you find and attract the best talent. Through to onboarding, making that sort of, introduction to your organisation as engaging and interactive as it can be before someone walks through the front doors. You're then into sort of the realms of central HR, which is all about managing people, data, process, collaboration, communication, benefits, rewards, case management, performance. There's a huge range of features available through Ciphr HR. And that then extends to e-learning, to manage learning content and to deliver learning journeys, through to payroll, be that in-house or outsource, and expense management. So there's lots of things that we do, but we're also really passionate about integrating with your third-party solutions as well. And essentially, that's just going to give you the ability to take control of your entire employee journey through our solutions, and getting again to that place where, one point of data entry, single source of truth. Look, we're a big believer that HR is, it sits at the heart of any organisation. You're dealing with your people from that first to last touch point. And we can give you the tools to manage that entire journey. Just some examples of some other organisations that have chose to use Ciphr. The reality is that Ciphr is an incredibly configurable solution. So whatever your contractual complexity is, your geographics, your makeup of people, it's about having a solution that isn't just able to work for you now, but able to sort of grow and adapt as you develop and progress as an organisation. So if anyone is interested in having a chat with us sort of after today, please reach out, as we'd love to understand what challenges you have and talk about how we can help you overcome them. So that's it for me, short and sweet, but I'll hand you over to the Shoosmiths team to take you through today's webinar.
Thank you, and thank you to Ciphr for inviting Stuart and I to share an employment law update with you today. So I'll be kicking off, and what I shall be looking at is sharing a case law update. We're then going to look at some of the recent changes to our legislation, what's on the horizon before I hand you over to Stuart, who's going to look at how you can protect your business and things to consider when drafting contracts. So first case for me today is that of Mr. Bathgate and Technic Singapore. And this case involves a question about the validity of Mr. Bathgate's settlement agreement. Mr. Bathgate had volunteered for redundancy, and he signed a settlement agreement which set out the key terms of this voluntary redundancy package. And the list of claims that were settled in the settlement agreement included claims for age discrimination and also included this generic waiver of all future claims. The settlement agreement stated that Mr. Bathgate would be paid this statutory redundancy package, and he'd also be paid this additional payment, which would be calculated by reference to a collective agreement that had been agreed between his employer and the union. However, the collective agreement stated that the payment would only be made to employees under the age of 61. At the point of his dismissal, Mr. Bathgate was 61, and for this reason, the employer stated that Mr. Bathgate was no longer eligible for the additional payment and didn't make it. Mr. Bathgate tried to bring claims for indirect age discrimination, arguing the terms of the collective agreement were indirectly discriminatory towards him on the grounds of age. And his employer argued that he could not bring this claim because he'd already signed a settlement agreement. And as part of that, he'd compromised his claims for indirect age discrimination against his employer. But also, in addition to that, even if he wasn't aware of this claim for indirect age discrimination at the time of his dismissal, the settlement agreement also included this generic waiver of all future claims. So I would note that this was a Scottish case. It was originally heard in the Scottish Employment Tribunal, then it went to the Scottish EAT and then their Court of Session. So it's not binding on English tribunals, but it can be very persuasive. The Court of Session actually agreed with the employer that Mr. Bathgate had compromised his right to bring claims of indirect age discrimination by signing this settlement agreement. And it's an interesting case because it considered an old case, which is still very much what we as employment lawyers go by. It was a Court of Appeal case called Hinton. And basically, this set out that whenever you draft settlement agreements, you need to be very careful to include the factual background at the beginning, but also to make sure you tailor that list of claims so that it's relevant to the particular circumstances. And the risk of failing to do so and leaving everything in the kitchen sink in that list is that the whole agreement could be rendered unenforceable. So that was established in Hinton. But furthermore, whilst we would include in our template settlement agreement a waiver of future and unknown claims, previously we'd flagged, look, this is more for deterrent purposes than anything else, because it was well established that individuals could only waiver claims that they knew about at the time of signing or that had arisen. And you'll often see where there's a gap between signing a settlement agreement and the actual termination date. We would always recommend a two-part settlement agreement where the individual at termination signs a further agreement just confirming that no further claims have arisen, or to the extent they have, that they are waiving them, so that it's belt and braces. Well, helpfully for employers, the Court of Session held in this case that future claims of which an employee does not and could not have knowledge of could be settled by a settlement agreement if it's plain and unequivocal that this was intended and the types of claims are clearly identified in the settlement agreement. So this case was quite unique in terms of background circumstance, but it does still demonstrate the necessity for settlement agreements to be drafted carefully, ensuring sufficient information and detail about future claims, unknown as well, are included when the agreement is signed. So just moving on to the next case. This is Mr. DeBank Haycox. It's a redundancy case. It went all the way to the EAT. And this case reinforces in the absence of consultation at the formative stages that will make a dismissal unfair. And this case involved an employer who was penalised for taking shortcuts in their consultation process. The facts of this case were that the claimant was employed by a recruitment company, and he was one of 16 who were assigned to recruit employees for a particular client company. Due to the COVID-19 pandemic, there was a reduction in the need for employers to do work of particular kind for this particular client. So the employer made the decision to reduce headcount within that particular client team. The US parent told claimant manager to score the team against this subjective selection criteria. And as a result of that scoring process, the claimant scored the least. Following a very short consultation process, the claimant was then dismissed. And at the time he was dismissed, he wasn't made aware about the selection criteria or how he'd scored or how he'd scored against others at all. So he appealed the decision, and at his appeal meeting, the selection criteria and scoring and everything else was made available to him, but his appeal was still unsuccessful. The claimant claimed for unfair dismissal, and whilst the ET had considered that any defect in the process had been cured at the appeal meeting, the ET disagreed and said that there had been an unfair dismissal because there was no meaningful consultation process carried out at the formative stage, and that couldn't be cured by any appeal. So it's well established from our case law the need to warn and consult with any employees on proposed redundancies. And part of this will be identifying the correct pool for those that are at risk, and then having a proposed objective selection criteria. And you should consult with employees on that proposed objective selection criteria in advance of scoring them against it. And then once having consulted with them, they should be scored against it, and then ideally objectively validated, and have a second person verify the scoring. All employees at risk should have their scores shared with them so they can challenge them if they consider it's unfair. Quite often you'll see employers take a view and share only with those provisionally selected, and I'll come on to why that can cause issues. But certainly those provisionally selected for redundancy absolutely need to have their scores shared with them at the formative stages of the consultation process. And they need to understand how they've ranked against others, not to see individual other scores, but how they've ranked. And then the rest of the consultation process should follow, where it should be meaningful and you look at ways to avoid redundancy. It is strongly recommended that you share scores with all of those that have been placed at risk, because as with lots of these processes, things change throughout. It might be the case you need to reduce further headcount and more people need to be made redundant. Or it might be the case that people in that bottom danger zone category successfully challenge their scoring, and then they rank higher and you have other people drop into that danger zone. Managers will also quite often know straight away as to who their top and low performers are. And we'll get clients say that they already know who has been kind of selected for redundancy. Please don't put that on paper. With the prevalence of subject access requests, it's just, it makes our job certainly a lot harder. We'll often have clients also tell us that they don't want to worry employees and put a whole pool of employees at risk, and they just want to apply the selection criteria and consult with that person who scored the lowest. Again, the risk of that is a strong risk of that is an unfair dismissal claim, so that will have to be balanced against your commercial interests. The next case that I wanted to share with you is Mr. Corby and ACAS. The claimant in this case was a conciliator at ACAS. He describes his race as white and the race of his wife and children as black, and he opposed the Black Lives Matter movement. And he published several posts on a workplace private forum saying he believed in the importance of character over race, and in particular, the woke approach to racism is misconceived, and seeing white people as a problem can result in separatism and segregation. He considered the approach of Martin Luther King, which desires a society where people are judged by the content of their character rather than their colour of their skin, being the approach that we should all take. And all races have in common humanity and their capacity to share this national culture. ACATS requested that Mr. Corby take down this post, but he refused on the basis that his views were a protected belief. And he brought a discrimination complaint in the Employment Tribunal, relying on this critical race belief as a protected belief under the Equality Act. And the first thing the tribunal had to do is decide whether this was a protected belief under the Equality Act. And so it applied our well-established test, the Granger test, and the criteria it has to look at to understand if this philosophical belief is can be protected in law. It has to meet the following. It has to be a belief that is genuinely held. It has to be a belief and not just an opinion or viewpoint based on present state of information. And it has to be weighty and substantial and dictate kind of how you live your life and your behaviour. It also has to have this certain level of cogency, seriousness and cohesion, and be worthy of respect in a democratic society and not be incompatible with human dignity and the rights, fundamental rights of others. So the tribunal did analyse Mr. Corby's kind of life and way of living and his behaviours, and they could see that these views did impact his behaviours and his way of life, and they considered that he did meet the Granger test. So he is entitled to protection under the Equality Act when expressing these views. So this case is just a reminder for employers that beliefs held by employees, even if they're voiced on social media and other platforms, can still benefit from protection under the Equality Act. This case has now been remitted back to the Employment Tribunal to make a decision as to whether he's actually suffered any discrimination. So watch this space. Moving on. The next slide that I want to, case that I want to share with you is that of Miss AB versus Royal Borough of Kingston. This case involved a claim of direct discrimination on the grounds of gender reassignment. And in this case, Miss AB had given the council 8 months' notice of her intention to transition, which she did in July 2020. For around 2 years post-transition, her name was not changed on her employer's systems, including its directories, email systems, and pension records. She was unable to rectify this without outing herself. And for a similar time period, her door pass, which gave her building access and printer access, wasn't updated. And a post-it note was put on her locker where her dead name, so the name that she no longer used post-transition, was crossed out, and a post-it note stuck on top with her transition name written on it. So Mrs. AB wasn't terribly happy about this, but also had raised safety concerns about a particular project, and she had worked on for the council. And a result of this, she was reprimanded by her manager, who she considered to have been derogatory and unprofessional. And she brought a claim of direct discrimination in the Employment Tribunal. And the tribunal upheld her claim and awarded her £25,000. £21,000 of it was injury to feeling. And the thing that the tribunal particularly focused on in this case was that the council's policies were significantly out of date. And they particularly criticised that given the size of the council, which had 4,500 employees and 60 in the HR team, that it was completely unsatisfactory. And it really counted against the council in the decision-making process. Another big issue for the tribunal was the significant delay and the lack of adequate reasons to explain this delay. And in the absence of that, it left the tribunal open to infer that the delay had been discriminatory. Not only were the policies out of date, you can probably guess the next thing, they hadn't provided any regular training either. And previous case law supports that regular training would be on a 12-monthly basis. So this really limited the council's ability to rely on the reasonable steps defence. So just to summarise, make sure that you've got up-to-date policies, make sure that you've got an equality and diversity policy, make sure that you have regular training on it. And if there are mistakes, let's not wait 2 years. Let's make sure that we correct them very quickly. So the next slide has a case called Mr. Omar. Bear with me whilst I try and change it. Mr. Omar versus Epping Forest District Council. So this case is one on resignation in the heat of the moment. And we often get asked by clients when they've received a resignation, should we accept it? And we'll say, well, it's not really our choice, or your choice, certainly, to accept or reject it. It's an individual's right to resign if they wish to. But the more troublesome area in this case kind of gives some helpful guidance on is when employees have resigned in the heat of the moment. And this case provides some guidance here on the rules that should be applied. So in this case, Mr. Omar, he resigned from his employment on the 19th of February during an altercation with his line manager. And he'd said things during this altercation like, I'm done with this organisation and take this as a month's notice. And later that day, Mr. Omar had spoken to the CEO, and the CEO soon recognised that actually he did want to continue in his employment. Safe to say, as a manager, had had enough of him by this stage. And a few days later, on the 21st of February, his line manager said he didn't want to continue working with him and had accepted his resignation, which would still stand. He asked him to put the resignation in writing, which Mr. Omar had agreed to do, but then later formally actually retracted his resignation. But his employer refused to accept that, and his employment came to an end, and he brought claims for wrongful dismissal and unfair dismissal. This claim made its way to the AT, and they gave some helpful guidance on how to evaluate resignations made in the heat of the moment. So the main points coming out of it is that no matter how the resignation is communicated, the employer must take a step back and consider the words used and whether a reasonable employer in that situation would have taken that as a resignation. So it is about taking a step back and trying to understand what's been said and how reasonable it is to accept it. And then once the correct notice has actually been given, it cannot be retracted without the agreement of the other party. You do need the consent. So the AT has sent this case back to the Employment Tribunal to consider these principles. We will hopefully have further updates in due course. So the next section of this presentation is on legislation update and what's on the horizon. You'll get copies of these slides. There is quite a lot of content in the slides, and for that reason, I'm not going to go into detail on the legislation update, but we really just wanted to flag them so that they are on your radar. So firstly, just looking at the Equality Act, there have been some amendments to that just to reproduce some key rights from our retained EU law, and those rights are outlined on the screen there. Flagging that the national minimum wage has increased as it does every year in April, and also some regulations made which remove the live-in domestic worker national minimum wage exemptions. The rates of statutory sick pay and family leave pay have also increased from the beginning of April, and you've got those rates there on the slide. There have also been some amendments to our employment rights regulations, in particular changes to holiday entitlement and pay. You'll have been very familiar with that increase in trend in case law on holiday pay, and really this legislation just puts that into statute. So a calculation of a week's pay should include payments intrinsically linked to the performance of tasks under the contract. So it will include those regular overtime and commission payments. And there will be this 52-week reference period. Rolled up holiday pay, can we keep up? It's in, it's out, it's in, it's out. It's now back in for your irregular hours and part-year workers. So you can use this holiday accrual on this 12.07% for anyone who started on or after the 1st of April. So that's quite helpful. Also, you'll have known from case law that in terms of rights of carryover, it is permitted where somebody's been, off on long-term sick or other types of statutory leave. And that's now being put into our legislation. But the COVID-19 provisions and rights of carryover have now been repealed. Also helpful, just flagging on this slide, some changes to our TUPE legislation, and the requirement to elect employee representatives will be removed for employers with fewer than 50 employees, or for employers of any size that have a transfer of less than 10 employees. So that's quite helpful, and that will be on or after the 1st of July this year. Small tweak to our working time regulations. You'll be familiar, if you don't have the 48-hour average working week or the opt-out of those provisions, that employers should keep a record of daily working hours. But it's been recognised that that isn't necessary if you can demonstrate compliance without doing so. We've now got the carers leave regulations that are in force that entitle employees with caring responsibilities to 1 week's unpaid leave in each 12-month rolling period, and for not to be put at a detriment as a result of taking that leave. Just to flag, in terms of maternity leave, adoption leave, shared parental leave regulations, so you'll be previously familiar that those on these types of leave, to the extent they're placed at risk during this period, they would have had first priority to be offered any suitable alternative employment. That right has now been extended for those during pregnancy and for a period after taking that relevant leave. And on the next slide, it kind of sets out what that further protected period is. So in pregnancy, and then for maternity leave cases, you've got this 18-month period after the date of birth, similar for adoption cases from the date of placement or the time the child enters Great Britain. Our paternity leave regulations have been slightly tweaked to allow fathers or partners to be able to take the paternity leave in 1 week or 2 week or 2 week block as opposed to 2 consecutive weeks, and they can be taken up to 52 weeks after birth or adoption, and slightly shorter notice provisions there. Just flagging, in terms of changes to our flexible working legislation, it's now a day one right that employees can make this request. There will be some further implementing regulation to enable employees to be able to make 2 statutory requests in a 12-month period, and for these requests to be dealt with in a two-month period as opposed to the current 3 months, but that's not quite yet in force. Immigration. Now, this requires a whole webinar in itself. There have just been so many changes recently, mostly just making it increasingly harder and more expensive to sponsor migrant workers. This slide just flags some of those increases. We've had increases in visa application fees, the immigration health surcharge, and civil penalty fines have gone up threefold from 20,000 to 60,000 per illegal worker. And so important to get those right to work document checks right. One bit of good news, sponsor licenses don't need to renew their license every 4 years now. So from after the 6th of April, they'll be extended for 10 years. Other changes that are already in play now are that the care and senior care workers can't bring dependents with them to the UK. That shortage occupation list that you'll be familiar has been replaced by what we refer to now as an immigration salary list. All the job codes have been recoded. That 20% going rate discount for shortage occupations has been removed. And then probably most startling is this very big hike in that minimum salary threshold for skilled workers, which has gone up to 38,700 now, or whatever the SOC code is, or going rate for that role, whichever is the higher amount. And quite often it is higher than that 38,700. That minimum salary threshold for also family visa applications has already increased to 29,000, with an expectation of another increase to the 38,700 by 2025. So lots of changes going on there. The immigration team, our immigration team, been very busy in the lead up to all of those changes. So in terms of looking at what's on the horizon, you'll have heard about the Neonatal Care Act. Government been talking about it for probably at least 2 years now. It's still not quite in play. Planned to be from April 2025 to introduce a new right for up to 12 weeks paid leave for parents of babies requiring neonatal care, where they've been in hospital up to the age of 28 days and been there for a full 7 days or more. The Worker Protection Amendment of Equality Act looks to come into force this October, which will introduce a new duty on employers to take reasonable steps to prevent sexual harassment of employees. And a failure to comply with that duty could see an uplift of up to 25% in cases of sexual harassment. The EHRC are due to implement a code of practice to reflect that duty, and it's subject to consultation at the moment. Just flagging on this slide some new provisions that are due to come into place this September to allow workers and agency workers to request a predictable work pattern where they've got that lack of predictability in their work pattern, and they can make up to 2 applications in that 12-month period and not suffer a detriment as a result. Non-compete clauses, so pretty radical, this proposal, confirmed proposal to cap non-compete clauses in employment and contracts to 3 months. Stuart's going to pick this up with you in his section. This proposal is just in relation to the non-compete clauses and not other post-termination covenants such as solicitation of employees, customers and the like, which still can be longer if justified. And this is proposed to come in when parliamentary time allows. And finally, just flagging, again, awaiting parliamentary approval, but this consultation on the code of practice for dismissal and re-engagement, where the code's looking to put in place a requirement to have meaningful consultation with trade unions and other employee representatives on an agreed solution, trying to encourage revisiting business plans to take all reasonable steps to explore other alternatives, and not using the threat of dismissal to put employees under pressure to accept new terms, and actually contacting ACAS before raising the prospect of dismissal re-engagement. And a failure to follow this code will result in an increase of any award up to potentially 25%. So that was a bit of a whistle stop, apologies, on the legislation horizon update, but the content is on the slides there. And so I'd like to hand you over to Stuart, and I think we'll take questions at the end when we know how much time we have.
Thanks, Sian. Right, over to me. Thanks to everybody who completed the poll. By some way, your favourite topic that you wanted us to talk about was things to consider when drafting contracts with the eye of how you go about protecting your business. I make no apology for the fact that I'm going to talk a bit of law this morning. We're employment lawyers at the end of the day. We quite like talking about law, but I am going to have to talk a little bit of back letter law, because I think it's really important that you get an understanding of the law that sits behind all of the clauses that go into the contracts. And it's also a little bit of a strange topic, isn't it? Because when you start out your journey and you recruit someone, it's always quite a positive. Recruitment is usually quite a positive process, and you don't really want to necessarily think about things not going well at the end. But it's really important that you do think about it. Not all employees are like Sian and I. We're Shoosmiths lifers. We've got combined service of about 40 years. Antonia, if we added Antonia as well, we'd probably have over 50 years, but that's another subject. So in relation to what we're going to talk about, I've got about half an hour, so I'm going to try and cover notice periods, pylon clauses, garden leave provisions, confidentiality, a little bit about intellectual property, but in relation to intellectual property, both Sian and I are specialist employment lawyers. We're not specialist IP lawyers, but I will touch on that. And we're going to particular focus in relation to restrictive covenants. So start off with notice periods. It's often overlooked that, I suppose, the starting point in relation to how you can go about protecting your business is to make sure that you've got adequate notice periods in place. The length of the notice period often reflects things like business continuity issues, how long you're going to need to facilitate a handover from a departing employee to the rest of your staff or to a new recruit, and in the context of new recruits, how long it's going to take you to recruit a replacement. And obviously, the longer the notice period, the longer the time you're going to have to do all of those actions. But the reality, the flip side of that coin is that if you put in place really long notice periods, and if for whatever reason you don't want the employee to work their notice period, and you either have to pay in lieu of notice or put them on garden leave, etc., then that's going to be an added cost to the company. We've put on the slide probationary periods. Obviously, you need to think about whether or not you need one and how long that's going to last for. Obviously, the normal advantage of having a probationary period is that a shorter notice period will apply. Please make sure that you've got the right to extend. In relation to tailoring to each role, absolutely. Notice periods, a bit like what I'm going to talk about later in relation to restrictive covenants, you should be tailoring your notice periods to role. The general position, of course, being that the more senior the employee, the longer the notice period. A question we often get asked is whether or not notice periods from the employer and to the employee, whether or not they need to be equal. There is nothing in law that says that they need to be equal, but bearing in mind the fact that in reality, it doesn't matter whether or not the employee is given notice or whether or not the employer is given notice. In relation to business continuity and handover and time to recruit, it's going to be the same. So a lot of the time we tend to see equal notice periods, but it's not an absolute requirement. The penultimate bullet point refers to a minimum period. So you can have, and we tend to see this in more senior contracts of employment, service agreements, are often used in a corporate transaction where senior managers or directors are rolling over, requiring employees to work for a minimum period before they can hand in their notice, unless, say, for example, the circumstances that would support a claim of constructive dismissal. But that can be a really useful one, not usually put in place for completely new employees, but we do tend to often see that in the context of corporate transactions. And the last bullet point is about wording to encourage a notice period to be worked. The reality of the situation is that if an employee doesn't work their notice period, there is actually relatively little recourse for you as the employer to take against the employee. You can include wording within a contract that says if you, Mr. or Mrs. Employee, don't work your notice period, then you will be required to pay the employer a sum equivalent to your notice monies. I've never seen it relied upon, but it is, if you are an employer who likes to draft things in a slightly more employer-friendly way, it can actually act as quite a useful deterrent to try and encourage employees to work their notice. But as I say, I've never seen it relied on. So next, the joy that is pylon clauses. Hopefully all of you are aware that pylon stands for payment in lieu of notice. Why would you have one? Well, if you choose to terminate immediately, or you don't require the employee to work and you don't want to put them on garden leave, then the advantage of having a payment in lieu of notice clause is that it enables you to make that payment without acting in breach of contract. And I'll come on to the consequences of acting in breach of contract in a minute. But it's a really useful provision. And generally speaking, they're quite easy clauses to, I suppose, exercise, but care is needed. Back in the day, there were some positives about having no payment in lieu of notice. So if there was no payment in lieu of notice clause historically, and you made a payment in lieu of notice, then what the law said then was that those monies that you paid to an individual amounted to damages for breach of contract, and those monies could be paid tax-free. Well, now we've got the joy of PEMP, or post-employment notice pay, and the government basically closed this loophole. Or the legislation was brought in to close that loophole. So whether or not you've got a payment in lieu of notice clause, any notice monies, if you pay them, need to be taxable in every single circumstance. So having a chat with Sian ahead of this session, our general view here is that we can't think of any occasion when it wouldn't be useful to have a payment in lieu of notice clause in your contract. So as I say, the main advantage is that if you have a payment in lieu of notice clause and you make that payment, you're not acting in breach of contract, because if you don't have it and you make the payment, then you are acting in breach of contract, and that can jeopardize and cause a real risk that the protections afforded under the rest of the contract will fall away, because you as the employer act in breach first, and that then means the employee can walk away from any of the other contractual obligations. The main one, of course, is restrictive covenants. So if you act in breach of contract, then the restrictive covenants can fall away. But you need to be clear. You need to be clear on how the payment in lieu of notice will be triggered. You'll need to be clear about how the pylon is going to be calculated. And the key point here is whether or not payment in lieu of notice is going to be limited to salary alone, or whether or not the employee in that situation will be entitled to benefits as well. Again, key point to flag is if there is no payment in lieu of notice clause in your contract and you make a payment in lieu of notice, then the employee will be entitled to salary, any benefits, and also any holiday that would have accrued during their notice period. So on this slide, what we've got is a summary of the pros and cons of a pylon clause. So it allows the employer to terminate immediately, protects restrictive covenants, and avoids acting in breach. You can limit the payment to basic salary alone, and depending on how your pension provision is drafted as well, you can potentially stop making pension payments. Now, here's a word of caution. I don't want to scare you here, but you do, just because of the numbers that I'm just about to talk about, but you do need to make sure that when you exercise a payment in lieu of notice clause, you do so carefully. And I'm going to talk about the Gaze case, which I think is one of those cases that caused shockwaves amongst the employment law community, just because it was an issue that hadn't really crossed many people's minds, and simply because of the numbers. So in this case, the payment in lieu of notice clause was worded as follows. So the employer reserves the right to terminate your employment at any time with immediate effect by making a payment in lieu of notice. Read that again. The employer reserves the right to terminate your employment at any time with immediate effect by making a payment in lieu of notice. That sort of wording is probably wording that you're reasonably familiar with. You may even have that wording within your contracts. So in this situation, what the employer did, they terminated at the beginning of December, but there was no mention to the employee about when they would be paid. The employee was paid in lieu of notice in December, but no explanation was provided and no notification was provided to the employee at that time. They were only told about the payment in lieu of notice in January. What the court said, the court looked at this clause. They said, well, actually, in this situation, it's not only a case of the payment in lieu of notice being operative at the point that the monies are paid, but the employee needs to know about it being paid. So actually, the effective date of termination, which is important from both unfair dismissal, but for other claims as well, wasn't the start in December when they told the employee that they were going to terminate. It wasn't the date in December when they made the payment. It was the date in January when the employee was notified of this. So what, you say? Why did that make such a difference? This individual worked in the financial services. He had what can only be described as a stonking bonus entitlement. And because his employment basically finished then after the completion of another calendar year, his bonus entitlement went up by, wait for it, £2.5 million. So there's a salutary tale for you. Please make sure your contract is wording carefully, and please make sure you exercise that wording carefully when you do so. Okay. Scare stories away. Let's move on to garden leave provisions. Again, we consider these to be really useful provisions, and our view is that in most circumstances you should have one within your contract of employment. The reality is that a lot of the time employers don't like exercising them. They don't like basically often paying employees for doing nothing, but they can be very useful. They can be particularly useful if your restrictive covenants are not drafted particularly well, and they can also be good if for whatever reason you don't want the employee to be working as normal, but you do need some assistance with things like handover, and you don't want the employee to be able to walk away and go and join a competitor straight away. So obviously, whilst on garden leave, the individual continues to receive pay and contractual benefits, but they are restricted from joining another employee. And normally, it requires an express clause in the employee's contract. We often get asked the question as to whether, if we haven't got an express clause in the contract, is there any form of implied right to put someone on garden leave? And that's when I'm going to sound like a typical lawyer and say it depends. It very much depends on the role that the individual is doing. If the individual's role and them working would then trigger some form of additional bonus entitlement or commission entitlement or increased salary, or by not working, then it will, I suppose, result in the employee becoming de-skilled, then the answer is likely to be no. Otherwise, you may well be able to run an argument that there is an implied right, but have a look at the role and take specific advice if that's something that you're looking to. And the other argument, of course, is that you can always agree it with the employee. If there's nothing in the contract, you can always agree to. And what we often see is a split between employees being placed on garden leave and them being paid in lieu of notice. So the key pros and cons are on that slide. I will leave you to digest those after the session. I think they're all relatively straightforward. I just would flag the fact that obviously, whilst on garden leave, they continue to accrue all of their benefits, and including holiday, albeit that obviously under the terms of the working time regulations, you could require an employee to take their holiday subject to you complying with all of the notice obligations, so that you haven't got a chunky payment in lieu of holiday that you need to make when the employment eventually comes to an end. Just some brief words in relation to confidentiality, because I want to focus most of my time in relation to restrictive covenants. Obviously, there are some implied terms in relation to confidentiality that you can rely on, but the key point is that any implied obligations in relation to confidentiality will fall away on termination. And that's the reason why you need express confidentiality provisions, so that you are protected after the employment relationship ends. What's really important is that you make sure that the definition of confidentiality is very, very tight, and very, very tight for your business. What one employer or how one employer will define confidential information will very much vary from another. We've obviously got Antonia, who you met on screen earlier on. She's our amazing professional supports lawyer who helps us with all of our precedents. We've got some fab starting point precedent wording that hopefully covers most bases, but it's still the case that we have to sit down with clients and take detailed instructions as to whether or not there's anything else that's not covered by our precedent wording. So a couple of weeks ago, I was dealing with the exit of an in-house lawyer from a client. Always good fun dealing with the exit of an in-house lawyer. And the client was very, very nervous in relation to confidential information. And we spent a long time racking our brains and really thinking about what other information the in-house lawyer may have been privy to during their employment, because what we did under the terms of a settlement agreement was basically introduce new confidentiality provision to make sure that the company was fully protected. I'm going to skip over the next slide. In relation to intellectual property, as I said at the start, Sian and I are both specialist employment lawyers rather than intellectual property lawyers. We've got a whole team here of intellectual property lawyers who help us with any tricky areas. The starting point is that, this is good news, is that a lot of the time, if you've got good IP wording in your contract, what it does is it simply replicates what the law says. The default position in relation to the law actually provides you with quite good protection, and it's not as strict for you to have really good IP clauses. But I'm conscious that we've got over 350 people online at the moment, but if you work for a company that creates a lot of IP, and your IP has got a lot of value to you, like it often does have, then again, the flag is make sure you get specific advice on it. A lot of the only other point I want to flag is that if you a lot of IP wording will be worded such that it contains a power of attorney, which basically, when it's signed by the employee, it enables the employer to sign documents to basically apply for or assign IP rights at the end of the employment or during the employment relationship. The only point there is to flag is that if you've got wording in your contract that includes a power of attorney, your contract must be executed as a deed. If it's not executed as a deed, then the power of attorney doesn't work. Okay, I'm going to use the rest of the session to talk about restrictive covenants. Oh, sorry, I just did a double click there. And to start off in relation to restrictive covenants, I just wanted to have a quick chat about why we need restrictive covenants. A question that often gets asked is, aren't there any implied terms that we can rely on? And the answer to that question is yes, there are. There are some implied terms that we can rely on, but there are some big buts to that. So there is basically the implied duty of fidelity. And what case law has developed is that there's lots of strands to that. And the main ones for our purposes today are the duty not to compete, the duty not to solicit employee.
Oh, sorry, everyone. It seems that Stuart's connection has just frozen there. Let's see if we can get him back. Oh, I've lost him now. Are you coming back, Stuart?
Camera just went. I think I'm back in the room.
Yeah, sorry, I turned your camera off. I was you'd frozen, and I was trying to revive you.
Okay.
But you are
Can everyone
back,
hear me now?
Yeah, I can hear and see you. Yeah, that's good.
Fantastic. Thank you. So secondly, there is the implied duty not to solicit customers and suppliers. And I want to bring that to life by an old case going back to 1935 involving Wessex dairies, where a milkman told his customers on his last day that he was setting up a new business, very competitive area, milk rounds. He would have been okay if he'd waited until the next day, because they don't, like the non-compete provisions, extend beyond termination. But because he told them on the last day, he was unfortunately caught. And the same applies in relation to duty not to entice employees. So given the limitations of implied terms, especially post-employment, that is why, and also given the potential harm that an ex-employee can basically do to you as an employer, that brings us to the world of restrictive covenants. So as set out on the slide, restrictive covenants can extend to the scope of implied terms for a period post-termination, but they should be designed to reflect your individual circumstances. As I say, one set of restrictive covenants for one client are going to vary very differently to another. But a lot of the time clients will say they're not worth the paper they're written on, and we turn around and say, well, actually, if they're properly drafted and they're reasonable, then you can very much restrict what an employee can do at the end of the employment. You can, and what the advantage of that from a protecting your business perspective is concerned, let's remember about the topic of today, is it can deter employees from joining a competitor. And often there's an obligation under a contract for an employee to have to bring to the attention of their new employer any restrictions that they're under, and it can actually deter competitors from employing employees. So in relation to the two types on the slide, there's two types. One's in relation to protecting information, so confidentiality provisions, and the other is in relation to activity. So you'll often see some or all of the following, so either non-solicitation, non-dealing, non-compete, non-enticement, or non-interfering. So when drafting these, you have to, and this is a bit of law here, you have to think about enforcement and the doctrine of restraint of trade. So this is all pretty standard stuff. For anybody who's spoken to me or Sian, or you've spoken to your employment lawyers, if you use other firms, you've probably heard the fact or similar spiel to this, which is that basically the starting point is that a restraint of trade is void. That's the starting point, and it's contrary to public policy. And therefore you can't restrict an employee unless, and this is key, unless you can show that you've got a legitimate business interest that warrants protection and the restriction goes no further than is reasonable. And we'll come on to that in a second, but that takes into account the interests of both the parties, so the interest of the employee to go and work and the interest of the employer to protect their business, and also there's a public interest element. Very fact specific, and it will vary, as I say, from one employer to the next. Okay, moving on. Hopefully everyone can still hear me. So what I want to spend time on is looking at legitimate interest. But before I do, I want to have a quick chat about the key principles that courts apply when applying and assessing restrictive covenants. So they'll need to have a think about what the legitimate interest is. They'll also think about the reasonableness. So you can only enforce if they are reasonable. And that's to say that takes into account the party's position, public policy. If they are too wide, then you will have no chance of enforcing them. There are very specific rules in relation to the employment relationship. What the courts basically, they approach restrictions in contracts of employment very narrowly. You'll get away a lot more with restrictions that are contained within corporate documentation. So under, let's say, share purchase agreements or documents that relate to a corporate transaction, you may be able to get away with more. Preventing competition in itself is not to a means to an end. You have to be able to show that you've got a legitimate interest. You've got to be able to point to the unfair advantage that the employee will be in if they're able to behave in the way that you're trying to restrict them. And that's many ways why provisions like non-solicitation are far, far easier to enforce than non-competition. As I say, the restriction must be no wider than is necessary. I've looked at one recently where there was no time limit, there was no geographic limit, and actually one of the restrictions made no sense whatsoever. So I had fun writing a letter back to the solicitor on the other side who was trying to rely on them to basically say, you've got very little chance, go away. There's some examples of the legitimate business interests on the side. It's really important that you think about the nature of your business and what the employee's position is. And we'll often see wording, or you should have wording within your restrictive covenants that actually identifies what your legitimate business interest is. And it's worthwhile spending time making sure that's in there. Trade connections, yes, absolutely. Case laws establish that it is a legitimate business interest for an employer to protect their relationships, and that reflects the fact that it simply takes time for a new employer or employees who take over, say, the work or the customer's responsibility within your organisation after an employee's left to build up those relationships. Trade secrets and confidential information. Yes, of course, we've talked about the fact that you've got implied terms, you'll hopefully have express terms, but sometimes that's not enough. It's quite hard to justify, but sometimes you can justify further restrictive covenants because the confidentiality provisions are not going to give you the protection that you need. Also, in relation to that, I just wanted to flag that there is a difference between confidential information and also information, or I suppose skills, experience, know-how that an employee acquires during the, I suppose, the day-to-day element of them working for an employer. That's not something that you can prevent. And then stability of the workforce, yeah, absolutely. Case laws confirm that it's a legitimate business interest where to basically control and make sure that this goes to the non-poaching or the non-employment point, that you can justify those pieces because of the massive impact where you're looking at team moves. The analogy I always give is that obviously I made reference to the fact that me and Sian have been here for quite a long period of time. We've been working together for 10 years. The impact of one of us leaving and joining a firm would be reasonably significant. The impact of both of us leaving and joining another firm would be a lot more significant. So hopefully that's a great way of bringing that to life. Okay, next slide. So what makes a covenant reasonable? It will be the starting point is the length of time, and it must be limited, and it will vary from case to case and from one restrictive covenant to another. Often you'll see the non-compete will be for a bit shorter than the rest of the restrictions, and a lot of that will depend upon the role, and also it will then depend upon, let's say for example, the interaction between the employee and their customer. So some people will have lots of regular interactions with their customer, and that ultimately means that the time it takes for those relationships to be built requires a shorter period of time than, say, let's give a classic example, an insurance broker. An insurance broker may only speak with their customers once a year when it comes to renewal. And therefore that might impact upon what the length of the time that can be justified as reasonable. I put on the next bullet point, offset of garden leave period. It is usually the case that you need to make sure that you've got wording that stipulates that if you put an employee on garden leave, then the length of the restrictions need to be reduced by a corresponding period. It's not always the case, but the vast majority of time it will be very difficult to justify both garden leave and the restricted period, because otherwise you get almost in a double advantage. Restricted periods, when I talk about that, I'm not looking about the restricted period going forward, I'm talking about restricted periods looking backwards. Absolutely, you need to, if you're referring to restricted customer, you'll need to talk about, okay, well, at what point is it fair for us to say, actually, if an individual hasn't had any dealings with a customer for, say, beyond the last 12 months, it's not fair for us as an employer to restrict them. And as ever, it goes to, I suppose the main point that I want to come across is the more bespoke you can make these clauses, the better. It goes to limits on competitors. The best ones that are drafted will be the ones that are really, really tailored. So where you've got, in relation to non-compete, if you've got wording that says along the lines of including but not limited to, and then you've listed specific competitors that you don't want an employee to go and work for, that is absolutely best practice. Think about whether or not you want to exclude personal connections. So if an employee has brought with them certain clients or customers, are you going to be happy for them to take them with them when they leave? And geographic scope is an interesting one. Again, it's role specific about whether you need to have a geographic limitation. For some roles, estate agents, hairdressers, things like that, you will absolutely need to have a geographic. It is a limit. For others, absolutely a lot more problematic, particularly when in this post-COVID world we live in, the ways of working are very, very different, and it's a lot more difficult to justify a geographic, or even try and address your mind as to what an appropriate geographic limit is. Last but not least, I just want to pick up again in relation to what John has said in relation to the fact that there's this proposal to limit the non-compete clauses. It's only the non-compete clauses where there is this proposal. The last time it was debated was on the 12th of May 2023, and as Sian's already said, it's going to be limited, or that the current position is that it's subject to when parliamentary time allows. I suggest, given what's coming down the track and what Keir Starmer has announcing today about things, everyone's ramping up a bit, aren't they, to some event that's going to happen in October, November. So watch this space. I'll put a bet on with anybody that is not going to come onto the statute books before the next election, but I may be wrong. And then last slide for me, it's just some last couple of points, and this is probably really a little bit more about restrictive covenants generally, but I just thought I'd put a couple of last points on there. One is, rather than just about when you're drafting them, but restrictive covenants will be reviewed at the point that they were entered into, not at the point that you seek to enforce them. So you won't be able to get away with giving junior employees really all singing, all dancing restrictive covenants in the anticipation that they're going to get promoted in years to come. what you should be doing is you should be reviewing your contracts at the point of promotion and adjusting your restrictive covenants accordingly. The other point is in relation to TUPE transfers. If you're involved in any TUPE transfers, then remember that when an employee transfers over to you, the restrictive covenants only bite in relation to the original employer's clients. They won't bite in relation to your clients. And also always make sure that you're offering employees sufficient consideration. We often tie up new restrictive covenants to either promotions or to pay rises. Last but not least, if you enter into new restrictive covenants on termination under a settlement agreement, you will need to pay separate consideration to ensure that those restrictive covenants are enforceable, and that payment will be taxable. Okay. So that's what I had to say. I hope that's been a really useful rattle through. It's 12:06, 12:07, just gone 12:07. Going to bring Antonia and Sian back. Have we had any questions that we want to cover?
Yes, we have got some. So Sian and I have been trying to reply to as many as we can during the webinar, but we've got a few that we haven't come to. They're not straightforward either, so I'll pose them to you. So we'll pick up one that's kind of fits in, I think, Stuart, with what you were talking about in terms of your restrictive covenant. So the question is, where does an employer stand if they've gone through and updated or changed their contract, so they've got more detail in there, but the employees refuse to sign? And in my mind, there are two potentials. So the employees may just never get round to signing, which we often see. You send out a contract and it goes into the void and nobody bothers to sign it and send it back. But if they continue to work under those terms, you might be able to rely on implied consent, although that in itself can be difficult, can't it, if the change doesn't take effect immediately. So if it's something like a restrictive covenant that will bite down the line, you have to be a little bit wary of implied consent. I guess if they refuse to sign and they make a fuss about it, they raise complaints, then they might be working under protest, and then you get into even more complicated waters.
And
I don't know if you've got any thoughts on that.
Yeah, and I think it also goes to the process that you're following about whether or not you're obviously, if you're doing a variation, are you, obviously the starting point is you're reaching agreement, and then as an employer, if you don't reach agreement, you're going to have two options. Are you going to impose the change on the employer, which could potentially be dangerous and risk unenforceability, or are you going to, is the change so significant that you're going to go down the dismissal and re-engagement route, and then the employee, then I think that in some ways makes it far more difficult for them to work under protest. It's a pretty bold step to take, but if it's an absolute business requirement that you introduce these new restrictive covenants, then that's always an option that's available.
The other thing to flag
until
is,
we get the Labour government who have said that they will stop the fire and rehire practice. So, sorry, Sian, you were
yeah,
going to
no,
say.
just flagging when introducing new restrictive covenants partway through employment, that need to have assigned consideration to it as well. So, even if they consent to it, but there's no specific consideration assigned, the risk of them being enforceable in those circumstances. So it's very, the consideration doesn't necessarily have to be monetary, but you do need to be kind of alive to that, and or possibly executed as a deed to ensure the enforceability of them partway through employment.
Okay.
Yeah. And we've had one about working time regulations. I think this was triggered from the legislation update section, Sian, that you were doing. But it was more a query about whether we advise employers to carry out regular checks with employees to see if they continue to opt in or opt out of the working time regulations, or is their decision on joining sufficient? I mean, any opt-out ought to give somebody the ability to give notice to bring it to an end at any point if they don't want to. I don't think there's a positive obligation on an employer to do that check-in.
I think it would
But
be
I
very
think
rare that, if they've opted out at the outset, you're not going to kind of check in with them to see whether they're sure they still want to opt out if it kind of the arrangement's working. I think where they haven't opted out and they're wanting to work, more overtime, that's going to take them over that 48-hour average, then they either need to opt out or they can't work, those additional hours. So I think in those cases you would be having further conversations.
The only way I've ever seen that done is where you have almost like an annual review process. If you're worried that employees' working practices are changing, you can send almost like an automated email to the employees to say, almost, our records indicate that you're not in this position. Please let us know if the position's changed. But the problem with that is that in some ways it can encourage employees to opt out. And as I said, I agree with you. I don't think there is a positive obligation, albeit that you've got a general obligation under health and safety to make sure that employees' hours of work are sensible and reasonable. Okay.
and then
Just squeeze one
sorry,
quick
Stuart.
one in. Is there any more?
Well, I'm not sure it is a quick one because it's about a carryover of holidays for sickness. So I think all I was going to say to that is I don't think the answer is straightforward. So the question was, do you need to carry over bank holidays if an individual's been absent, if you give holiday over and above the statutory minimum? So I think the starting point is for regular hours workers, normally you'd only carry over the directive leave, which is the 4 weeks. That's all you'd need to allow carryover. But we've had the case of Agnew last year that says if you don't properly distinguish between what is your 20 weeks of directive leave and what is the additional leave, it forms a composite pot. And then you get into questions about, well, what holiday has been taken and what's left to carry over. So it's not a straightforward question. So I would say to that person, if it's something they're worried about, maybe they could come and talk to us directly, because there are lots of considerations to bear in mind.
And that, ladies and gentlemen, is why we always have Antonia on these sessions. Thank you, Antonia. Thank you, Sian. Okay, I think Catherine's going to rejoin to say some concluding words. So just finish from us, just to say thank you very much. It's been a pleasure to support as ever. Thanks, Catherine.
Yeah, thank you, Stuart, Antonia and Sian, so much for your time and expertise today. We really appreciate it. Thanks, James. We heard from you a long time ago, it feels like, but it was great to hear from you at the start, and thanks for sticking with us. For anyone who has joined us today, thanks for joining us. We appreciate your attendance and your participation in the chat. When we close this webinar, there'll be an opportunity to offer some feedback. We love hearing from you to find out what we could do better next time. There's also the option there to opt in for more information about Ciphyr's HR and payroll solutions, or to hear from the team at Shoosmiths. We can happily put you in touch with them if you drop a message in there. I can see lots of messages to chat in our chat, so yeah, we'll pick up on those. Stephanie, you want to get their email addresses? Let me just throw those back on the screen. If you want to reach Stuart and Sian directly, their email addresses are on there. You can also just give them a Google, and their contact information on Shoosmiths' website will pop up too. Thanks everybody. I hope you can join us for another Ciphr webinar again soon, and have a great rest of your day. Take care.
Thank you.